Hello, everyone. My name is Jim Seberg. I'm the Assistant Director from the Medical Cannabis Research Center at Drexel University. Today, we're happy to be joined by Patrick Nightingale. Patrick is the president of the Pittsburgh chapter of NORML, also a lawyer at PKN Law. Patrick, I'll turn it over to you for a more in-depth introduction.
Fantastic, and thank you very much for having me, Jim. My name is Patrick Nightingale. I'm primarily a criminal defense attorney practicing in state and federal court here in Southwestern Pennsylvania, though I have had occasion to represent clients federally in the lovely city of Philadelphia, which is always a pleasure to go to your federal courthouse. I am a medical cannabis patient myself. My wife and I were activists joining the dozens of other grassroots activists back in 2013, 2014, 2015, while we were, getting legislation moving through Harrisburg to pass medical marijuana. And as Jim said, I'm the director of Pittsburgh's chapter of the National Organization for the Reform of Marijuana Laws, the nation's first marijuana advocacy nonprofit, which was founded shortly after the war on drugs and the Controlled Substances Act was passed. It's my pleasure today to talk to you about our Medical Cannabis Act. And I'm going to go through some of the basics of the act. I think that we're all probably fairly familiar with the fact that we do have a medical cannabis law in Pennsylvania. And then I'm going to shift to the protections that Pennsylvania patients have and some of the areas where we simply don't have protections, and talk a little bit about some of the legislative efforts to fill in some of these gaps. So I tend to like to do things with a PowerPoint presentation. So with no further ado, let's pop this up. There. Can everyone see the PowerPoint presentation? Jim, we good? All right. Again, my name is Patrick Nightingale, and we're going to be talking a little bit about the nuts and bolts of Pennsylvania's Medical Cannabis Act. I am very flexible with entertaining questions. I'm happy to go in whatever direction the audience may like to take this, but let's jump into it. This is Pennsylvania's medical cannabis law. As an attorney, I teach a lot of attorneys about this, so you're going to see statutory references, and it is codified at 35 Pennsylvania Consolidated Statutes, annotated at section 10231.101 et sec. So that is where the entire medical cannabis law can be found. The medical cannabis law, there were legislative findings that cannabis can provide effective treatment for certain qualifying conditions. Our medical cannabis law creates a framework for Pennsylvanians to register as medical cannabis patients. It creates a physician's registry with training requirements for physicians. It supersedes Pennsylvania's Controlled Substances Act for patients and caregivers who are acting in compliance with the act. And the medical cannabis law also sets forth a list of all available medical cannabis products. Section 102 is where we find the legislative intent. That is where the legislators said, this is what we're trying to accomplish with Pennsylvania's medical cannabis law. And the important thing about this is for lawyers like myself, when we go into court and we make argument about statutes, judges will often look to the legislative intent. What did the legislature mean to do when it created the medical cannabis law? And it's clear that the General Assembly wanted to create a program that allowed patients with qualifying conditions access to medical cannabis. But subsection 4 on this slide, right down here at the bottom that I just highlighted, this has been something that has kind of been a little bit of a challenge in moving certain patient issues forward. Because what that says is that if the federal government ever legalizes marijuana or deschedules marijuana, it sets a 2-year sunset clause into action, which would literally cause the end of the medical cannabis program. I'm not exactly sure why they put that in there, but when I have litigated cases before the Superior Court arguing that marijuana should not be Schedule 1, the first thing the Superior Court says is, wait a minute, the legislature did not intend to make this a permanent solution. This was just supposed to be an experiment. See, in Section 4, they put in this clause that said it will sunset. the program will be over if federal law changes, and that has caused a lot of consternation in trying to argue that it was really the General Assembly's intent to take medical marijuana out of a Schedule I classification. Moving right along, we have qualifying conditions. We originally had a list of 17 qualifying conditions: cancer, HIV, AIDS, ALS, Parkinson's, PTSD, intractable pain, chronic pain, autism. We were the first state to have sickle cell anemia as a qualifying condition, and I think one of the only states to have autism as a qualifying condition. In August of 2018, then Secretary of Health, Dr. Rachel Levine, approved adding anxiety, Tourette's, terminal illness, cancer in remission, opioid use disorder, and neurodegenerative diseases. And it has turned out that anxiety has become the leading qualifying condition, followed closely by chronic pain and then PTSD. This is something that is very important for patients, and it was accidentally not adhered to when the program first went online. Patient data information is 100% confidential under Pennsylvania's medical marijuana statute. This is not HIPAA. This prevents the Department of Health from disclosing patient information. Now, January 1st of 2018 was the first day that the program went live. And at that time, the Department of Health made patient information available, and it wasn't until patients reached out to the governor's office and said, wait a second, this was prohibited by statute. You are not permitted to put any of this information online, that they took it off. And why is this so important? Well, obviously, private medical information is that patient's own concern. But it's also important when it comes to law enforcement encounters, because what I have found in my practice, and we're going to touch on this a little bit later, is that often when a law enforcement officer during a traffic stop learns that a patient is, or that the motorist is a registered patient, they will know that that motorist will at the very least have non-psychoactive metabolites in their blood. They know that under Pennsylvania law, any metabolites is a DUI. So they'll then investigate that patient for a cannabis or a controlled substances DUI. If this information was not confidential, every time a police officer pulls up behind a patient, and there are now over 425,000 patients active in our program, then that officer would be able to initiate a DUI investigation right then and there. So this confidentiality, from my perspective as a criminal defense attorney, is very important. And it's interesting because what I get from a lot of law enforcement officers is, Pat, we just want to have a way to check to make sure your client's ID is valid, and we don't have a hotline to call. If it was a driver's license, we can look at the at driver's licensing and seeing if the license is valid or not. And my answer is, well, one thing that is possible is the patient can bring a receipt from the dispensary. The patient can show a recent purchase that has the purchase date demonstrating that the card was valid, but that does not seem to be anything that the Department of Health intends to provide any funding for, or to allow a law enforcement hotline. So we're just going to have to deal with some cops who don't want to believe that the patient identification is valid. Lawful use. And this is something that jams up patients, especially patients who are using cannabis either recreationally or medically before the law passed. And specifically, we are not permitted to smoke marijuana under our program. Smoking is prohibited, even though dry leaf is available at our dispensaries. And a lot of patients who, like I said, are kind of old heads, they don't understand that they cannot smoke their medical cannabis. And when they do smoke medical cannabis, they lose the protections of the act. You are now no longer lawfully using medical cannabis. Now, the cannabis that you may be smoking, you probably cannot be prosecuted for. However, the smoking paraphernalia that you're using is not covered by the act. The act does allow patients to possess devices necessary to consume medical cannabis pursuant to the act. That does not include a smoking bowl, papers, cones, or bongs. It can only be vaporized. Edibles are prohibited, but a patient may make their own edibles. And I don't know how many patients are in this group, or if you've been to the dispensary recently, but there are now lozenges that are available. They're not quite edibles, but they are lozenges that you can suck on and place under your tongue to administer cannabis sublingually. And there are even soft lozenges, which are almost like gummies. But edibles are not otherwise permitted under our act. Senator Dan Lawful from Erie has introduced a bill to allow edibles. I don't know if that bill has much of a chance of moving through the Republican majority in the Senate, but he put that out there. That's one of only 2 bills that are actually filed right now. And then finally, growing and dispensing is prohibited. The only people that can grow cannabis in the Commonwealth of Pennsylvania are licensed cultivator processors, the MSOs, or the clinical research facility. If a patient grows a single plant, it is a felony. And patients may not dispense medical cannabis to each other. My wife and I are both patients, and under a strict reading of the law, I cannot allow her to hit my vape pen, and she cannot allow me to hit her vape pen. Because dispensing covers not only retail sales, but also exchanges of medical cannabis between patients. So if a law enforcement officer comes across a patient who has some other patient's medical cannabis, that patient is subject to prosecution under the act. We have a caregiver system in Pennsylvania. As it was originally set up, a caregiver could only have 5 patients, but after the governor's emergency pronouncements during the pandemic, a caregiver may now have unlimited patients. And I know that there was at least one dispensary in the eastern part of the state that were making their retail employees caregivers so that they could engage in home delivery of medical cannabis. As I said, and I'm sure that being the School of Medicine, there is a physician registry for physicians to register with the Department of Health, take a 4-hour course to demonstrate at least some knowledge of cannabis and the endocannabinoid system. I think I haven't taken the course myself, and the Department of Health maintains a list of approved physicians. A patient can go to any physician anywhere in the Commonwealth of Pennsylvania, and one of those pandemic-related emergency provisions that has become statutory law is that telemed is now available for both initial consultations and for renewals. Interestingly, Senator Mike Regan, the chairman of the Senate Judiciary Committee, a former United States Marshal, he has circulated a co-sponsorship memo seeking to eliminate the physician registry and to eliminate the list of qualifying conditions. And his goal seems to be to try to bring more patients into the medical cannabis program. And quote, "I'd like to see Pennsylvania look more like Oklahoma." And if you're not familiar with Oklahoma's medical marijuana program, it is a very lightly regulated program, and over 10% of Oklahoma's population of 4 million people are registered medical cannabis patients. I don't know when Senator Regan intends to introduce that legislation, but he did circulate the co-sponsorship memo, and he is in the Republican leadership in the Senate.
You too, sir.
I'm sorry? Oh, there's a question: is the growing prohibited because of the Pennsylvania medical cannabis law, or does the Gonzalez case from Supreme Court still have relevancy? Gonzalez v. Rake is obviously a Supreme Court precedent, and in Pennsylvania, our statute prohibits the growing of any plants for any reason whatsoever. The only exception is in the Medical Cannabis Act that says license holders may cultivate. Now, if we change the law in Pennsylvania and said, for example, patients may cultivate up to 5 plants, or indigent patients may cultivate up to 10 plants, or whatever the case may be, that is nothing that the Department of Justice, even in adult use states, has sought to intervene with. So in the law, we have this concept called the Supremacy Clause, where federal law reigns supreme. And where federal law conflicts with state law, federal law supersedes state law. Now, in the early days of medical cannabis, the Department of Justice was cracking down on medical cannabis grows in California and prosecuting them under federal law. under the federal budget, the Department of Justice may not use its federally appropriated funding in order to go after well-regulated medical cannabis programs. And that's why, for example, the Department of Justice has not tried to shut down any of Pennsylvania's license holders or Pennsylvania grows. But they have also decided to take a blind eye to adult use programs. That budgetary spending rider does not apply to adult use states. But even so, the Department of Justice seems to have absolutely no interest in trying to enforce federal law against states that have legalized, as long as the operators within the state are acting within the confines of state law. So in Michigan, if you're allowed to grow 12 plants, the feds aren't going to mess with you. But in Michigan, if you decide to grow, 1,000 plants, then you may very well have an issue with federal enforcement. And I see another question in the chat. Yes, the Commerce Clause absolutely applies to Pennsylvania. The Commerce Clause is federal law. I mean, we must comply with the Commerce Clause. Violation of the Commerce Clause. If a state attempted to, for example, erect barriers at the border and require someone to pay a tariff before coming into Pennsylvania, or if an Ohio manufacturer had to pay an extra 5% to sell their products in Pennsylvania, that would be in violation of the Commerce Clause. And what really is the issue here is federal Schedule I classification that prohibits any type of interstate transport. And for states that are new to growing cannabis, where do they get the seeds? I guess they just magically appear and they don't travel in interstate commerce. So that's kind of a nudge, nudge, wink, wink that seems to be, that we all seem to pretend doesn't happen. So Attorney General Sessions and Bill Barr were against marijuana and abandoned the Cole memo. Current federal policy is discretionary. That's true. There's nothing that would, well, with the exception to medical marijuana, on medical marijuana, the Department of Justice is not permitted to use its congressionally authorized funds to go after well-regulated medical cannabis programs. And that would include, in my opinion, patient protections. And I'll get into that when we talk a little bit about Second Amendment issues. But the Department of Justice does retain discretion for adult use and obviously for illegal cannabis. I do a lot of federal work. I can tell you that the feds, at least here in the Western District of Pennsylvania, see themselves as having more important things to do than to worry about cannabis, because we have a big influx of methamphetamine. We're dealing with a lot of fentanyl, with a lot of heroin. Crack cocaine is coming back. And they're spending their resources on felon not to possess firearm cases as a way to try to address some of the increase that we're seeing nationally in firearms violence. Yes, you are correct that it is challenging when you have a state with both medical and adult use, especially for federal enforcement. But we've simply not seen federal enforcement in adult use states anywhere in the country, as long as the entities in those states are complying with state law. There's a little bit about the patient certification process. You have to register with the Department of Health, get a patient ID, consult with a physician who's registered with the program, provide medical documentation that you do have a qualifying condition. That physician will then approve you participating in the program, notify the Department of Health. The Department of Health will send you an email asking to pay a $50 fee. You pay the fee, and then you get your medical cannabis card issued by the Department of Health. There's annual recertification that is required, so you have to pony up that $50 to the Department of Health every year. And when you do register with the Department of Health, you have to demonstrate that you are, in fact, a Pennsylvania resident, either with the driver's license number or with your official Pennsylvania state ID. Acquiring and using medical cannabis, a patient may go to any licensed dispensary in Pennsylvania, must present their patient identification as well as a driver's license or a Pennsylvania ID card. A patient may purchase any cannabis products unless their certifying physician places limitations on those products. There are criminal penalties for illegal diversion of medical cannabis. And this is something that unfortunately gets some of my clients caught up. the medical cannabis must be kept in its original dispensary packaging. So if you're smoking flower or if you're vaporizing flower, that flower has to be kept in the jar or the packaging from the dispensary. If you're using hash oil concentrates, same thing. And if you're using, to me, if you're using vape cartridges, what this means is that you can't just have your cartridge on its battery when you're not actively hitting it. You need to take that cartridge off of the battery, put it in its original dispensary packaging until you're ready to use the cartridge again. Now, if you're at home, chances of having a law enforcement encounter in your residence over, not fully complying with the Medical Cannabis Act is likely not going to happen. But if you're a motorist and you have a law enforcement encounter, there's the opportunity for an officer to see that you do not have the original dispensary packaging, and that could cause seizure of product or being charged with violating the Controlled Substances Act. We do not have reciprocity in Pennsylvania. If you're a medical cannabis patient from Ohio, you are out of luck in Pennsylvania. If you're from West Virginia, if you're from New York, if you're from New Jersey, if you're from Virginia, if you're from Maryland, if you're from DC, if you're from Arizona, Nevada, Michigan, Oregon, Washington, California, you may not use medical cannabis in the Commonwealth of Pennsylvania. Now, some of those states give reciprocity to Pennsylvania patients, and a lot of those states are now adult use, fully legal states. So, the issue of reciprocity is not relevant. But for a Pennsylvania patient who is traveling out of state, they want to be very mindful about whether or not they'll be driving through states that completely prohibit the possession of medical cannabis. And if the state to which they are traveling, either via air or via motor vehicle, train, bus, if that state offers reciprocity or any type of protections to medical cannabis patients. I've had clients that said, wait a minute, I'm legal in my state. How can I be prosecuted in Pennsylvania? Well, we simply don't offer reciprocity. Or someone saying, hey, I traveled to North Carolina and I was charged with a crime because they don't have medical marijuana and they didn't recognize my medical marijuana card. It's not legal in states like that. I mean, and it really affects the ability of patients to exercise their constitutional right to travel. Because if I am dependent on my medical cannabis, how can I travel to a state that prohibits it, that will arrest me and prosecute me for it? These constitutional arguments were used in a lawsuit against the DEA in 2018, but unfortunately, because of other procedural requirements, that lawsuit was not able to move forward, and that constitutional claim was never fully developed before the court. Effects of inhaled cannabis. I'm sure we're all familiar with this. There's a rapid onset. The effects, tend to last up to 2 hours. Peak effects within 15 minutes. And once it is inhaled, it rapidly begins to metabolize into the psychoactive metabolite and the non-psychoactive metabolite carboxy-THC. Carboxy-THC cannot be used to prove impairment, and urine tests only screen for metabolites. So urine tests can only tell you whether or not someone has metabolites in their system, but not whether or not there's any active delta-9 THC actually in the patient's system. And when I talk about DUI in a couple of minutes, we're going to talk about why this issue of carboxy-THC is so incredibly important and dangerous for Pennsylvania patients who are motorists. These are the penalty provisions that are actually set forth in the Act. Penalties for a practitioner certifying a patient who does not have a medical qualifying condition, misdemeanor of the first degree if an employee or any investor or operator or principal diverts medical marijuana. So if an employee at the dispensary tries to put something in their bag, they're violating not only Pennsylvania Controlled Substances Law, but also the Medical Marijuana Act. It's a misdemeanor of the third degree if a patient or caregiver retains more than the permitted amount, which is a 90-day supply under the expanded emergency provisions from the pandemic that are now statutory, but we don't really know what a 90-day supply is. When the program first started, I thought that a 30-day supply was 60 grams of hash oil concentrate, which is a pretty hefty amount of hash oil concentrate for most patients. And a 90-day supply then would be 180 grams of hash oil concentrate, but that's not defined anywhere in Pennsylvania law or in Pennsylvania regulations. It's a misdemeanor of the second degree if a caregiver or a patient illegally diverts medical marijuana. And that's actually a more serious offense than if I was not a patient and I handed you, 10 grams of weed. That is an ungraded misdemeanor called possession of a small amount of marijuana. So it's interesting to see that that there are increased penalties within our act. And it actually escalates to a misdemeanor of the first degree for a second or subsequent offense with a mandatory period of, I believe, 90 days incarceration, which is far more serious than actual Pennsylvania controlled substances law. If I were to give you, for example, like I said, 10 grams, 15 grams, up to 30 grams of weed, I can give that to another person. And under Pennsylvania's Controlled Substances Act, the maximum penalty that I face is a $500 fine and 30 days incarceration, no matter how many times I do it. And when I saw this, I saw someone who was charged with this, and I brought it up to my state representative and some others, and they all agreed that under no circumstances did they intend to make the punishment worse for a patient who diverted medical marijuana than for a non-patient to divert it. But there's really no movement afoot to try to address these penalty provisions. Is medical marijuana Schedule I under Pennsylvania law? Yes, it is. And this is where I had talked a little bit earlier about that sunset clause causing the Superior Court to say, wait a minute, the General Assembly did not say that medical marijuana had medical benefit. They merely said, let's experiment with whether it does or not. Maybe it does, maybe it doesn't. And if federal law changes, then we're going to shut the whole thing down. It was an absurd dodge from the Superior Court to kick it back to the General Assembly and say, hey, yes, you passed this law. Yes, it does not fit the definition of a Schedule I controlled substance, but you guys fix it. It's not up to the judiciary to fix it. And remember, Schedule I means that there is a high potential for abuse, no currently accepted medical use in the United States, and a lack of accepted safety for use under medical supervision. Cannabis as a whole doesn't fit that definition, and medical cannabis most certainly does not. But we are stuck with that in Pennsylvania. And that is incredibly important, as we'll get to in a couple of minutes when we talk about DUI. Our Medical Cannabis Act provides certain statutory protections for patients. In addition to allowing a patient to possess and consume what is otherwise a Schedule I controlled substance, there is protections for patients and caregivers and physicians relative to professional licenses. I'm a licensed attorney. I'm a medical cannabis patient. Section 2103A says that the disciplinary board may not punish me or take disciplinary action against me for any reason whatsoever, solely based on my status as a medical cannabis patient. Now, if my use of medical cannabis rendered me ineffective in court, then there could be disciplinary action taken against me, but not simply because I'm a patient. Similarly, there are custody protections for parents engaged in custody litigation. Merely being a medical marijuana patient is not relevant. In custody litigation, you look at the certain criteria as to what's in the best interest of the child. And unless a custody litigant was able to show through credible and demonstrable evidence that the other parent was not meeting their parental duties because of medical cannabis use, then medical cannabis is not something that a court is to consider when making a custody determination. But what is missing from this is dependency. Dependency is where a parent is accused of not providing adequate care, custody, and control for their child. You see that a lot with people who may be addicted to narcotics, and they're not caring for their child, and children and youth services will come in. They'll file a petition with the court that says this child is not being cared for by their parents at home or their mother or father, and we need to now make this an active case to protect the interests of the child. We don't have any dependency protection for parents, and it is certainly possible, though I'm not personally familiar with it, that a children and youth organization or a caseworker could bring a dependency petition or allegation against a parent solely based on that parent's medical marijuana use. There are also employment protections for medical cannabis patients, and this is a very active area of litigation right now. What our employment protection says is that an employer may not discharge, threaten, refuse to hire, or otherwise discriminate or retaliate against an employee solely because of that employee's status as a medical cannabis patient. However, the employer is not required to accommodate medical cannabis use at the workplace, and the employer is not required to make any accommodation that would put the employer in violation of federal law. So what have we been seeing? Well, first, what this section doesn't say is that an employee who is fired because they are a medical cannabis patient has a right to sue. But Pennsylvania courts have interpreted this section as giving employees a right to sue if they're discriminated against. Additionally, there are issues that come up when a patient, let's say, applies for a job, is told that they need to take a drug screen, and then after they fail the drug screen for cannabis, they go back to the employer and say, but wait a minute, I'm a medical cannabis patient, you still have to hire me. Under those circumstances, the employer can say, you didn't reveal it to us before you took the drug test, so therefore we're not going to honor this, and we're not discriminating against you because we made the job offer before we knew you were a medical cannabis patient. Other areas are, let's say, for example, the employer is a trucking company. They're regulated by the Department of Transportation. Marijuana is a Schedule I controlled substance federally. That employer would not be subject to allegations of discrimination under this solely because they were regulated by the Department of Health. And Section 510 of the Act gets a little more specific about certain dangerous jobs. And what Section 510 says is that an employer may not have more than 10 nanograms per milliliter of Delta-9 THC if they're working with dangerous chemicals, high voltage electricity, or in another public utility, performing duties at heights or in confined spaces, such as mining. They may be prohibited from performing tasks that the employer deems life-threatening to employees, and they may be prohibited from performing any duty that could result in a public health or safety risk. What I can tell you is that in the last legislative session, there was a bill called Senate Bill 749 that wants to radically expand Section 510 that would make it much easier for employers to discipline employees that they suspected may be under the influence of cannabis, and to strip employees from other rights that aren't fully delineated in the Act. We recently had a decision by the Commonwealth, two decisions by the Pennsylvania Commonwealth Court, that workers' compensation carriers are required to cover the costs of medical cannabis products for employees who are receiving compensation. One of the things that Senate Bill 749 would do would be to statutorily prohibit workers' comp carriers from providing, from being required to pay for medical cannabis. And there's already a provision in Pennsylvania's medical cannabis law that says that insurers are not required to cover the costs of medical cannabis. I'll see another question in the chat. Give me 1 second. Prospective employer, yes. If someone is applying for a job and they do not reveal medical cannabis patient status and then fail that pre-employment drug test, that employer is free to refuse to hire, and that employee has no remedy at law. So for someone who is applying for a job and they're told that there is going to be a drug test, they must reveal medical cannabis patient status at that time, or they lose the protection of Section 2103C.
So Patrick, for that particular question, they still do have the protection of the clause if they reveal it once they are told that they have to take the drug test, but if they wait until after the drug test to reveal it, they are not protected.
Correct.
Okay.
That's how courts have been ruling. I don't think we have appellate case law on that specifically, but the employment attorneys that I refer medical cannabis patients to me say, that's their first threshold question. Before before you took the drug test for the new job, did you reveal patient status? No, I didn't. Sorry, we can't help you.
Could I ask a question in regard to the idea of any duty that could result in public health or safety risk? Because ultimately, I know pilots, nurses, providers, they're probably under the risk that they should not be using this substance while they're in their job. That's what I've been told from lots of these patients with these.
Section 2103 says that an employer is not required to accommodate use at the workplace. So what I generally tell people is that it's one thing if you're using when you get home, but if you're using medical cannabis at work, your employer is free to put a policy in that medical cannabis use during the workplace or at the job site is not something that is going to be permitted. And I haven't seen much, if any, litigation under Section 510 where an employee says, "Wait a minute, my job, was not something that would result in public health or a safety risk, or I was not, doing one of these enumerated restrictions under Section 510." But it's a real issue, and that's why I think that employers, especially manufacturers in Pennsylvania, are trying to tighten this up and get more protection so that they're not subject to liability, and they can have a more clear-cut policy to potentially discipline, fire, discriminate, or move employees or medical cannabis patients out of the types of jobs that would be considered safety-sensitive positions.
So related to that, Patrick, are healthcare providers, physicians themselves, doctors, nurses, are they considered, if they use off the job for medical purposes as a patient, are they not protected by that? Would that be considered a public health risk?
Well, Section 510 would not apply to use of cannabis outside of the workplace after work. Because what Section 510 says is that employee may not be under the influence of medical cannabis when doing certain types of jobs. And under the influence is defined as 10 nanograms per milliliter of active delta-9 THC. So if you if before you start your shift at the hospital, you hit your vape pen in the car 4 or 5 times, you're going to be in violation of this already, because you're going to be over 10 nanograms per milliliter in what is arguably a public health or safety sensitive position. But if I finish my shift at the hospital, I go home, I use medical cannabis, I go to sleep, I wake up the next day and I go to work, I am not going to have anything remotely near 10 nanograms per milliliter of cannabis in my blood, so I'm not in violation of Section 510. It seems that Section 510 is just trying to, it's Section 510 and Section 2103 is the employment discrimination, but I think that the purpose of Section 510 is to say there are certain jobs that we consider too risky, and you're not going to be permitted to use medical cannabis on that job site regardless, whether or not your employer has a policy about it or would otherwise accommodate it. If you're doing these types of jobs, then you cannot use cannabis or you cannot be under the influence of cannabis while you're performing the job. Use after work wouldn't risk this. Use before work could potentially risk this.
Great. Now we have one more question in the chat. Do healthcare institutions have the right to disclose they do not hire people who use marijuana in hiring requirements? Is that considered discrimination if it's posted rather than not disclosing at the hiring process, but then being denied employment with a drug screening?
All right, let me see that question again. Can a hospital say essentially we're not hiring medical cannabis patients? I think that would depend on the job in a lot of cases. Because if a hospital said we're not going to hire a janitor who's a medical cannabis patient, I think that would be potentially discrimination under the Act. When it comes to nurses and physicians, that's starting to get above my pay grade a little bit. I apologize because I'm not an employment lawyer, but I think that there would be a risk of that discrimination unless the hospital made the case that whatever the position is federally funded, and there could be federal funds that would place us at risk of losing that federal funding if we hired someone who's a medical cannabis patient. It seems that 510 does allow medical marijuana users in high-risk positions to use medical marijuana out of the workplace. Yes, it does. What Section 510 restricts is having 10 nanograms or more of Delta-9 THC in your blood at the time that you're performing the job. Here's what I wanted to, another question. What do we got? Oh, you're welcome, Thomas. This next section is what I call the single most important issue facing Pennsylvania's medical cannabis community, and it's not something that anyone talks about until after they have a negative law enforcement encounter. In Pennsylvania, under our DUI law, under the controlled substances subsection of our DUI law, if you are operating a motor vehicle with any amount of a Schedule I controlled substance or its metabolite, you are DUI in Pennsylvania without any proof of impairment actually required. And what we are finding is that patients who inadvertently reveal medical cannabis patient status to law enforcement officers are now suddenly being asked to perform a chemical test, because that officer knows that if I'm a patient, I'm going to have at least carboxy THC in my blood, and therefore they can jam me on a DUI regardless of whether or not I exhibit any signs of impairment whatsoever. I'm working with Senator Bartolotta's office from Washington. We have a bill pending before the legislature right now, Senate Bill 363, and it would require proof of actual impairment similar to a Schedule II or a Schedule III prescription narcotic. Because under Pennsylvania law, if you're using the medication that your doctor prescribes you, Schedule II or Schedule III narcotic, and you are not impaired by it, you're not going to get a DUI. But if you're using benzodiazepines or opiates or whatever, and it does impair you, you can get a DUI in Pennsylvania. You know, when you have that prescription bottle and it says, do not operate a motor vehicle, this may make you feel dizzy, maybe get used to the effects of the medication. What that bottle should say is if this medicine impairs your ability to operate a motor vehicle safely, you will get charged with a DUI, regardless of whether or not you're following your physician's instructions. But for patients, we don't even have that. Every single patient in the Commonwealth of Pennsylvania who uses medical cannabis and who operates a motor vehicle is DUI 24/7, 365. I got up this morning and I drove to a prison in Youngstown to visit a client. I used medical marijuana last night before I went to bed. Under Pennsylvania law, I was guilty of DUI as I was driving to the prison to visit my client today. That was not the intent, but when we were working to pass this this law in Harrisburg, one thing we heard over and over again is like, listen, we're at the goal line. We just need to punch this in, score the touchdown, win the case, pass medical marijuana, and then any issues that we have, we can just come back and fix later. Don't let the perfect be the enemy of the good. Let's just get this passed and then we'll fix it. Well, we passed this law in 2016. Yesterday was the 7th anniversary of Governor Wolf signing the medical marijuana law. Patients first began purchasing medical cannabis on February 15th of 2018. I was privileged to be one of the first to purchase up at the Cresco Yeltra, now Sunnyside dispensary in Butler, Pennsylvania. And for 5 years now, we have been trying to get a law through Harrisburg that would require proof of actual impairment similar to Schedule II and Schedule III controlled substances. Because, let's say this is your first time ever being charged with a DUI, you'll get a diversionary program. A second offense within 10 years, 90 days in jail and an 18-month license suspension and mandatory ignition interlock on your vehicle, even though ignition interlock cannot possibly detect cannabis. Third offense within 10 years, you're going to the state prison for a year. Now, think about that for a second. The General Assembly has said, we think that it is very important for Pennsylvanians to have access to this non-toxic medicine as a treatment alternative. But don't you dare drive a motor vehicle. And if you do and get caught, then you're ultimately looking at spending a year with the Department of Corrections. And now, you'll say, wait a minute, does everyone who has a third DUI within 10 years go to prison for a year? No. Most states have a diversionary program called DUI court, where someone says, listen, I'm an alcoholic, I'm struggling, I'm addicted to drugs, I'm struggling, I need treatment. District Attorney's Office will approve a year of house arrest, intensive treatment, follow up, to really try to help this person recover from their addiction without requiring them to go to prison. Well, guess who doesn't have an addiction and who doesn't require treatment? Medical cannabis patients. And I have had judges say to me, I am not allowing your client into my DUI court because your client says that they're not addicted to marijuana and they don't need treatment. So I say, Judge, what's my alternative? My client's supposed to go to prison for a year. The alcoholic gets treatment. The opioid addict gets treatment. The pill addict gets treatment, but the person who's lawfully complying with Pennsylvania's medical cannabis program gets to go to the Department of Corrections. And, fortunately, the few judges that I've had this issue in front of have given me house arrest and not sent my client to prison. But, it's a real issue that we're dealing with. Oh, I see a couple of questions in the chat. What is the right to refuse a chemical test for patients? There is no right to refuse a chemical test. Pennsylvania is an implied consent state. If an officer has reason to suspect that you may have a controlled substance or the metabolites of a controlled substance in your blood, they can ask for a chemical test. And if you refuse, you automatically lose your driver's license for a year. And if they really wanted to be awful about it, they can get a search warrant and force you to give up that blood anyway. And the one comment I saw before that, one thing that I tell every single patient as much as I can, during a traffic stop, never, ever, 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 and I mean never, reveal medical cannabis patient status to that law enforcement officer, because there's a lot of guys and women out there who don't like the fact that medical marijuana exists, who don't like drugs, and if they can jam you on a DUI, they will. And that's especially prevalent in areas out in the eastern part of the state, kind of like in the NEPA area. I hear just time and time again, out of Lehigh County, Lancaster County, up in that area, how awful state police are. That as soon as they find out that you're a medical cannabis patient, they treat you like you've been shooting heroin for the past 3 weeks. So I say it to every patient. And I just consulted with a poor gentleman this morning. The officer said, do you have anything that I should know about? Do you have any guns, any drugs in the car? Are you a medical marijuana patient? And the patient volunteered, yes, I'm a medical marijuana patient. Next thing you know, they're going downtown for a chemical test or going to the hospital for a chemical test, and now they've been charged with DUI. Other issues for patients, there are no housing protections under Pennsylvania's medical marijuana law. A landlord would be free to discriminate against a patient. A landlord would be free to put in their lease, no one may use a federally Schedule I controlled substance under any circumstances, and that patient is out of luck because we don't have any housing protections within our Medical Cannabis Act. It also affects Second Amendment rights. In Pennsylvania, you can be a marijuana user, whether it's a legal or illegal marijuana user, and still have a right to possess a firearm. Under federal law, there is no right for a medical marijuana patient to possess a firearm. And concealed carry in Pennsylvania makes reference to federal law. It says, are you otherwise prohibited from possessing a firearm under federal law? Medical marijuana patients are not recognized under federal law. So a person who wants a concealed carry permit is faced with either I lie and I hope I don't get caught, or either I don't get my concealed carry permit, or I have to give up my medical cannabis patient identification and stop using medical cannabis. And the same with purchasing a new firearm in Pennsylvania from a federally licensed firearms dealer. There's a reference to federal law, and a patient is forced with the issue of, do I lie on that form and risk a felony prosecution, or do I simply not purchase a new firearm, or do I leave the program, acquire my firearm lawfully, and then get back into the program? One thing that I talked about a little bit earlier was the federal budget prohibiting Department of Justice from prosecuting well-regulated medical marijuana programs. At least one federal judge in Michigan said that the Department of Justice would not be permitted to prosecute a patient for possessing a firearm under federal law if that patient was otherwise in compliance with Michigan's medical marijuana program. The facts of that case demonstrated that that patient was not in compliance, so the prosecution continued, but it was at least some precedent for the idea that if the Department of Justice cannot enforce it, then a patient cannot be prosecuted for it. Well, I see some questions up in the chat. What are the difference between Pennsylvania and federal firearm laws? And I'll get to Professor Werner Simon. I'm familiar with the Cease case, and I actually litigated the Jesse case. So give me 1 second on that, Professor Werner Simon. But to Tina Brunetti, under federal law, specifically 922G3, Title 18, United States Code 922G3, no individual who is an unlawful user of a controlled substance may possess a firearm. Under Pennsylvania law, you do not become a person not to possess without disqualifying criminal convictions or being subject to a protection from abuse order. So that's kind of the big difference between federal and state law. And I'll touch on the Bruin decision before I go back to the professor's question. Over the summer, the United States Supreme Court held the most expansive Second Amendment decision in the history of the Second Amendment, and it was the case of New York Rifle and Pistol Association versus Bruin. And what the Supreme Court has said, that if you want to regulate firearms, there must be a historical analog or something that was on the books at the time that the founding fathers or the framers of the Constitution passed the Bill of Rights. So, for example, in Texas, the Rahimi case, protection from abuse orders didn't exist in the late 18th century. So therefore, prohibiting someone from possessing a firearm who was subject to a protection from abuse order was unconstitutional. Similarly, in Oklahoma, there was no prohibition of the town drunk having a firearm. So there was no, the framers would have had no sense of prohibiting someone from possessing a firearm because they unlawfully used controlled substances. Now, here in Pennsylvania, the Third Circuit has said that Bruin only applies to law-abiding or virtuous citizens. So there's a split between what Texas and Oklahoma is doing, what Pennsylvania is doing, and this has ultimately got to go back to the United States Supreme Court so they can figure out this mess that they have created for everybody. Now, I want to go back to Professor Werner Simons, the Mary Cease case. Yes, that case was decided by the Commonwealth Court. And in that case, the Commonwealth Court essentially said, we are applying Pennsylvania medical marijuana law in federal housing regulation, and said, we think that Pennsylvania's medical marijuana law ultimately supersedes federal law on this particular issue. It was a 2-to-1 split between the Commonwealth Court judges. Personally, I don't think that that decision was properly decided. I think that federal public housing regulations supersede Pennsylvania's Medical Marijuana Act, but the Commonwealth Court, I think it's because Mary was a very compelling plaintiff herself as a disabled veteran, that they said, no, we're going to carve out a workaround. So the law in the Commonwealth of Pennsylvania right now is that if you are applying for Section 8 housing, you cannot be prohibited from Section 8 housing on your medical cannabis patient status. And then once you're in Section 8 housing or federally subsidized housing, you can't be kicked out of it for medical cannabis use. And until that goes back, the Pennsylvania Supreme Court did not take it up. So unless the issue comes up again with a different decision from the Commonwealth Court, that is the law of the land. And the professor references Commonwealth versus Jesse. And Commonwealth versus Jesse was my case. It was before the medical marijuana program. My client had a grow with about 400 plants back in 2014. Well, we litigated it, but it didn't come right to have our suppression hearing until after the medical marijuana law was passed. So I decided, hey, now that we have medical marijuana in Pennsylvania, how can it be constitutional to prosecute my client for violating a statute that defined cannabis as a Schedule I controlled substance? So I took it up on appeal to the Superior Court, and the Superior Court initially shot me down on that. It's a temporary measure. The General Assembly never intended it to be to say that medical marijuana had medical efficacy. And then the Jersey court carved out this wonderful little piece of language that said, and besides, if it is medical marijuana, then it is not scheduled by Pennsylvania's Controlled Substances Act. And that gave us a lot of hope to say, wait, then maybe this gives us some relief for a medical marijuana DUI, because how can you charge my client with a Schedule I DUI for medical marijuana? But unfortunately, the Pennsylvania Superior Court recently in Commonwealth versus Stone said, nope, we're not applying JESI to DUI. Medical marijuana remains Schedule I under Pennsylvania law until the legislature says differently. Oh, one more question. My patients asked me if they can keep their gun license with their medical marijuana card. We don't have a gun license in Pennsylvania. We have a concealed carry permit. And a strict reading of Pennsylvania's concealed carry law says that if while you're in possession of, while you have your concealed carry permit, if you become disabled, then you are required to give your concealed carry permit up to the local sheriff. And the idea for medical marijuana, I have my concealed carry permit, I then become a patient, and my medical marijuana use is in violation of Pennsylvania's concealed carry permit statute, I'm supposed to then surrender my concealed carry permit. Practically speaking, I am not familiar with patients who have had law enforcement encounters resulting in their concealed carry permit being taken away from them. But practically speaking, if I were to have a law enforcement encounter and that law enforcement officer would see my medical patient ID and my concealed carry permit, chances are they're seizing that concealed carry permit and then forcing me to go to court to try to get it back, which I would not be able to do if I was actually using medical cannabis. Oh, the question is, dronabinol treated like medical marijuana? No, that's it's Schedule II, I believe. It's either Schedule II or Schedule III. So, it's outside of the Medical Cannabis Act, and it's actually can be prescribed. Well, we're at 5:02. I'm happy to stay on and answer some more questions. Anyone have anything they want to throw out here?
Yes, Tina, if you want to hop on mic, feel free to read.
Great. Can you guys hear me?
Yes.
Yes.
Excellent. So today I met with a colleague of mine. She's actually a certifying physician for the Pennsylvania Medical Marijuana program. And she asked me this question. I was a little flabbergasted. So she certified a 16-year-old girl for the program 2 years ago. And her parents were her caregiver. She turned 18 and she recertified her again. And her parents are always there with her. But she also applied for her driver's license, okay? She got this letter in the mail from the Commonwealth of Pennsylvania Department of Transportation. Information submitted to PennDOT indicates you may have a substance use condition that could affect or limit your ability to drive. In order to determine if you meet PennDOT's medical standards for driving, it is necessary for you to undergo one or more physical examinations. Then they sent her this form, which, Pat, you may know what form this is. It's the DL-128. It's the substance use form. I thought this was all confidential.
It should be. I have no idea how the Department of Transportation or how PennDOT would receive or be somehow tipped off to that. It is confidential. This is between the patient, the certifying physician, and the Department of Health. Correct. And unless one of them provides this information to PennDOT, I don't know. I have no idea how PennDOT would find out about that, and that is very distressing.
Yes.
Because PennDOT is going to say, you're not permitted to operate a motor vehicle if you have any metabolites in your system. I mean, technically, I don't think PennDOT could prohibit that person from getting a driver's license per se, but that person, and I don't even know if there's something that is flagged on a driver's license for some type of controlled substances disorder. But that is very, very chilling, because one thing that I was going to touch on this next slide is touches on the issue of patients who are under probation or parole supervision in the Commonwealth of Pennsylvania. A judge or the parole board cannot prevent a patient from using medical cannabis, but in the Butler County probation office, there's a big sign that says, if you're a medical marijuana patient, you may not operate a motor vehicle while you're subject to Butler County probation supervision. And technically they're correct, because every time that probationer gets behind the wheel of a car, they're committing a DUI, regardless of impairment. But that is very, very chilling. And I'm going to see if I have any colleagues that have come across that.
I appreciate that. Thank you so much. And if you want me to send you, make a copy, you scan it to you, I would be happy to. Let me know.
Please do.
Awesome.
But
Thank you.
There's my email address, pknlaw@mac.com. Please send that to me. I'm very interested in that.
Thank you so much. I appreciate it, Pat.
Anybody else? All right. Well, allow me to say thank you very much for having the opportunity to join you, Jim. Thank you very much for the invitation. I hope that I was able to provide some information to help. And if you have any questions, there's my contact information. Feel free to reach out.
Yeah, thank you so much, Pat. It's been an absolutely great presentation. I think we've had some great questions, and looking forward to staying in touch. And hopefully we can get you back on for a follow-up and see if you can help out with Tina's case there. Definitely looking forward to seeing everyone at the Pennsylvania Cannabis Festival this weekend. If anyone will be up in the Poconos, Drexel will be there. We will be having another speaker series on May 10th coming up, talking about patient and physician relationships. Feel free to look out for emails on that. Thanks again, Patrick. It's been great. And I hope you all have a great weekend.
Great. See you in the Poconos.